Hi, my name is Carl Pearson. I'm a New York attorney and graduate of Harvard Law School, and I'm preparing this video for homeowners in the 62 counties in New York State to help them understand and deal effectively with threatened foreclosure actions to be brought against them. I've been defending foreclosure actions throughout New York State for many years, and I'm able to explain to threatened homeowners what is now happening with residential foreclosures. I'm preparing this video to enable homeowners who are having problems in paying their residential mortgage in any of New York City's, in New York State's 62 counties, to understand the basic problems they should be addressing as soon as possible to give themselves the best opportunity of saving their mortgaged home. The rules and issues are constantly changing, somewhat like a swinging pendulum. The rules and at this point, homeowners face a more difficult time than they have had during the past 5 years to save their property, and have a much greater need to defend their interests through litigation for reasons I'm to discuss in this video. I'm going to make a series of important points which may not seem related, but they all play an important part in the process of saving homes from foreclosure. And you should know what these points are to give you the best opportunity to save your home from foreclosure and sale. 1. The two most important points that come to mind are, first, that you need to retain an experienced foreclosure defense attorney and experienced loan processor, usually working with that attorney, to represent your interests in dealing with the lender. The second most important point is for the homeowner to get started as soon as possible in doing what needs to be done to save the home. The reason for this is that for every month you do not pay your mortgage, there generally is a decreased opportunity for you to obtain a loan modification agreement. The lender, assuming in the first place, which may be an assumption contrary to fact, that it really wants you to remain in your home, is less able to provide you with an affordable loan modification agreement as your unpaid monthly payments keep increasing, because in many or most modifications as of today, the lender loses at it, it forgives the unpaid amounts and doesn't have a federal subsidy, and will refuse to do so at a particular level, or the rate of interest needed to be charged in a loan modification will be too high for the homeowner to afford. Accordingly, the second most important point to remember is that time is working against you. The longer you fail to make your monthly mortgage payments, the more difficult it will be to save your home. You should remember this second point, because often banks are dragging their heels deliberately to have the unpaid amount get to a level that makes a loan modification agreement impossible and enables them to foreclose upon and sell your mortgage property. This leads directly into the third point, which is that most lenders, some at the outset of a homeowner's default and others at some point thereafter, really aren't interested in giving a loan modification agreement and do many things to sabotage a defaulting homeowner's efforts to save the property from foreclosure. This sabotage can occur in a variety of ways. The first way: there comes a time after a homeowner's failure to make 1, 2, or perhaps 3 monthly payments in a row that the lender will often decide not to accept any payments at all, even if the homeowner offers to make up all unpaid amounts. This is necessary for the lender if it wants to maintain a foreclosure action against the homeowner. Acceptance of even one payment or even a partial payment would be a waiver of the homeowner's current default and prohibit the lender from commencing a foreclosure action until the homeowner goes into default again with another 1, 2, or 3 unpaid monthly payments in a row. Most homeowners may not be aware that at a certain point in their default, the lender will refuse to accept payment. The second way: even though some of the major banks and loan servicers have been offering loan modification agreements known as HAMP, these are federally subsidized modifications and the money is getting used up. And these very few banks and services are starting to go back to their old technique of finding fault with applications so they can say the application was never made in full, or delaying in their decisions, or using erroneous information to wrongfully deny applications that should have been granted. Most homeowners and many others attempting to help homeowners probably do not have the knowledge or experience necessary to understand the complex rules under which loan modification applications are processed and sometimes granted. My law office is different. We have the skills to make loan modification applications in accordance with the appropriate rules, understand what the lender is giving, when the lender is giving us the runaround or doing something wrong, and know what, if anything, can be done to correct the problem. The person who is mainly responsible for doing this is known as a loan processor, and it is in the homeowner's best interest to work with a knowledgeable, experienced loan processor to have the best chance of obtaining a loan modification to save the mortgaged home. Also, the same loan processor is needed when attempting to obtain approval for a short sale, which some homeowners realize is what they need if it becomes clear that they are not going to be able to obtain an affordable loan modification agreement, or perhaps decide not to try to save the home because it is so far underwater that they would be paying 20 or 30 years on the mortgage and obtain no equity to speak of. The third way, because of the securitization of mortgages that have been taking place during the past 20 years or more, and the creation of Mortgage Electronic Registration Systems, Inc., also known as MERS, or MERS Corp., or MERS Corp Holdings, Inc., the ownership of your note usually cannot be determined with any certainty unless your loan came from a local savings bank or local savings and loan, or a smaller commercial bank, or a friend or relative, none of whom could be expected to securitize your loan, your home loan. When a home loan is securitized, as most of them are, the note is permitted to be sold, and whoever buys and takes possession of the original note is permitted under law to foreclose on the note, assuming it is in default, because the note is treated as a negotiable instrument somewhat similar to the treatment of a $100 bill. A store owner or a bank doesn't ask when the presenter of a $100 bill obtained that bill. It doesn't matter unless the bill is a counterfeit. MERS, among other things, is a stock exchange for defaulted notes and mortgages, where they are sold by banks and services to other banks, services, or investors, too many of whom are vulture funds not interested at all in giving loan modifications and instead buying the note for the purpose of obtaining judgment of foreclosure and sale and selling your property and removing you through eviction proceedings from your home. MERS allows these transactions of buying and selling your note and mortgage to take place without your knowledge and without any recording of the transactions, often for years, in your county clerk's office, so that the homeowner usually cannot tell for certainty who owns the note, and it could be owned today or transferred tomorrow to someone who has no interest in giving a loan modification agreement, which is another reason not to let your mortgage get too far behind, to try to prevent a sale of your note and mortgage to a vulture fund. Fourth way, there are lender rules for those banks and other note owners or loan servicers who claim to be interested in accepting loan modification applications and granting applications that limit applications in a variety of ways, such as by not permitting multiple applications, by exceedingly short periods for acceptance, sometimes expiring before the loan modification offer is received, by limiting change in circumstances that preclude another application even though the homeowner now qualifies, by using the wrong figures to improperly deny a loan modification application, and a variety of other techniques, including a slowing down of the process by the lenders or servicers' attorneys to cause the amount outstanding to reach a level where grant of a loan modification is considered to be not possible. A homeowner needs to be represented by a team, that is, an attorney and loan processor, capable of dealing with these all too often complex problems involved in saving a home from foreclosure. Now, getting away from the problem of delay, I want to get into the problem of loan modification companies, which also use loan processors, which I now call my fourth point. Loan modification companies do not provide legal representation, and they are not permitted by federal and state law to accept compensation for work done as to properties located outside of their state. Also, they are not permitted to charge for loan modification work unless and until the homeowner has actually accepted a loan modification offer, and then the amount of compensation is limited to $2,500. Recently, I saw an agreement with a loan modification company which, if a principal reduction was granted, the homeowner would have to pay the company 10% or an additional $10,000, assuming a $100,000 principal reduction, or 5% of any amount the bank lost on a short sale from what had been owed. Both of these provisions are illegal under federal and state law. Various wrongful practices in the loan modification industry by various persons, including loan modification companies, loan processors, finders, banks, servicers, attorneys, and others, caused federal and state statutes and rules to be created which now enable homeowners to avoid dealing with some of the less reputable persons but make it more difficult to find competent help. Attorneys are regulated by these rules, but they are permitted to be paid for services if they are part of their foreclosure defense or related services. Fifth point, an important part of saving your home is to get started as soon as possible to arrange your financial affairs so that, if possible, you qualify for a loan modification agreement, assuming that the lender or servicer is willing to give you one. Your attorney and loan processor need to look at your income, mortgage debts, including second and third mortgages and other liens, and other debts to see what can be done to make you more eligible for a loan modification or to prepare you to defend a foreclosure action, which gives you an additional tool not available except in a foreclosure action. Sixth point, although you may believe to the contrary, there is no duty of a lender or loan servicer to deal with you, the homeowner, mortgagor, in good faith. The lender or servicer merely has to comply with a written agreement. But in New York, under Section 3408F, the CPLR, during the mediation period known as conferencing, the lender or servicer and its attorneys have a statutory duty to act in good faith when dealing with your loan mitigation options, including a loan modification application or application for a short sale, or even when dealing with a deed in lieu of foreclosure. These are things that can be done, there are things that can be done for the homeowner prior to any foreclosure action, which will give the homeowner a better chance during the conferencing period to obtain a loan modification agreement, because of the possibility that to deny such an application might create serious issues of bad faith and bad faith litigation. Loan modification companies probably are not in a position to help in this area because they are not permitted to practice law. Seventh point, homeowners need to remember that usually when you are assigning an interest in your property to someone who has a plan to assist you in saving your home, such assignment will destroy or severely cripple your chances of obtaining a loan modification agreement. The reason is that the lender or servicer will want to have full disclosure of all deals which your new partner has, and the mortgages and unrelated debts such as a partner is attempting to service. This becomes very cumbersome and costly and gives the lender or servicer a great opportunity to drag its heels, keep asking for more documentation, and ultimately deny any loan modification agreement. Also, it can raise issues with a judge concerning the propriety of the transaction, which could scare the lender or servicer away from offering any relief. Get competent advice before you convey any interest in your property for the purpose of saving your property. Such conveyance may cause you to lose your property. To sum up what I'm trying to say, the banks and their services are either not wanting to grant loan modifications, or, as to most major banks and their services, have used up or almost used up their federal subsidies to grant loan modifications, which means that loan modifications are decreasing in availability and increasing in monthly cost and decreasing in principal reductions. This means that there are going to be more foreclosure actions and that homeowners need to be prepared on both fronts with the best available loan modification services through a knowledgeable and experienced loan processor and a knowledgeable and experienced foreclosure defense attorney if a loan modification is not granted. Not all homeowners can save their home without dealing with a foreclosure action for reasons I've just discussed. When a foreclosure action is commenced, the battle for saving the home continues, but with the added cost and tools of litigation. All foreclosure actions differ in a variety of ways, and an attorney has to study the relevant documents and analyze and discuss with the homeowners to determine what issues to raise in the defense of the homeowner in the homeowner's answer to the complaint. Shortly after the summons and complaint are served, the homeowner has an opportunity in the conferencing period under CPLR 3408F to try to obtain a loan modification agreement, and the threat of costly litigation as evidenced by your timely answer with affirmative defenses by a competent foreclosure defense attorney signals to the lender or servicer and its attorneys that they may be better off granting a loan modification agreement than trying to spend what could be years in costly litigation, including appeals, during which the lender's equity in the mortgage is being used up and the loan is not performing. The combination of a skilled loan processor and skilled foreclosure defense attorney seems to be the best opportunity for most homeowners to save their home when facing foreclosure and sale. This is pretty much what I have to say, and if you have any questions, please give me a call at 212-307-4444. That's 212-307-4444. I look forward to hearing from you.